An Introduction to Constitutional Law, 100 plus Supreme Court cases everyone should know, by Randy Barnett and Josh Blackman. Whole Woman's Health versus Hellerstedt, 2016. The Supreme Court's abortion jurisprudence has not followed a straight line. Roe versus Wade held that the right to an abortion was fundamental. Accordingly, abortion restrictions were reviewed with strict scrutiny. And the state only had an interest in protecting fetal life in the third trimester after the point of viability. The next major abortion case would come in 1991. Planned Parenthood versus Casey upheld Roe's central holding, yet made several important changes. Critically, the joint opinion adopted the undue burden standard. Moreover, the plurality found that the state had an interest in protecting fetal life throughout all 9 months of the pregnancy. Following Casey, the composition of the court would change. Justices White and Blackman retired. They were replaced by Justices Ginsburg and Breyer in 1993 and 1994, respectively. In 2005, Justice O'Connor announced her retirement. She would be replaced by Justice Alito. Additionally, Chief Justice Rehnquist passed away. He would be replaced by Chief Justice Roberts. In 2006, the Roberts Court began. 1 year later, the court would hear its first major abortion case. Gonzalez versus Carhart upheld the federal ban on partial birth abortions. The vote was 5-4. Of the 3 justices in the Casey plurality, only Justice Souter dissented. Justice O'Connor was no longer on the court. Justice Kennedy found that the federal law was consistent with Casey. He also wrote the majority opinion in Carhart.
We find the Act does not impose an undue burden by reason of its lack of an exception for protecting women's health. The Court has given state and federal legislatures, in other cases, wide discretion to pass legislation in areas where this medical and scientific uncertainty exists. Physicians are not entitled to ignore regulations that direct them to use reasonable alternative procedures.
After Carhart, the composition of the court would change again. In 2009, Justice Sotomayor replaced Justice Souter. The following year, Justice Kagan replaced Justice Stevens. The new Roberts Court began in 2010. 3 years later, Texas enacted 2 controversial restrictions on abortion providers. The first provision required that doctors who perform abortions must have admitting privileges at a hospital within 30 miles of the facility where the abortion is performed. Many doctors in rural locations would have to stop performing abortions because they could not obtain such admission privileges. The second provision required that an abortion facility must be designed to operate and meet the standards of an ambulatory surgical center. Compliance with these standards would be very costly. Further, this requirement was also imposed on clinics that perform abortions with medicine and not surgery. Taken together, these regulations would have forced most abortion clinics outside of big cities, including Whole Woman's Health, to close. After taking evidence on the costs of and claimed need for these regulations, the District Court found the law was unconstitutional, but the Fifth Circuit Court of Appeals reversed. The Roberts Court granted certiorari in November 2015. However, in February 2016, Justice Scalia suddenly passed away. The shorthanded court heard oral arguments 1 month later. And in June 2016, the court decided Whole Woman's Health versus Hellerstedt. Because Justice Kennedy sided with the challengers, the vote was 5-3. Consequently, Justice Scalia's vote likely would not have made a difference. Unlike in Casey and Carhart, Justice Kennedy would not write the controlling opinion in Whole Woman's Health. Instead, he assigned that task to Justice Breyer.
We find that they are not consistent with the constitutional standards set forth in Casey, and we hold both provisions unconstitutional.
Study guide. What level of deference is owed to laws promoting health and safety that impact abortions? Here the court considered both the burdens and benefits imposed by Texas's law.
We follow, as we must, Casey and Gonzalez here, and in doing so, we decide whether there is undue burden, looking to the existence or non-existence of medical benefits, as well as the burden the law imposes on a woman's access to abortion facilities.
During oral argument, the Texas Solicitor General countered that under Casey, the undue burden test
examines access to abortion. Now, if a law had no health benefits, presumably it would be irrational.
However, considering the health benefits,
that has never been the test under Casey.
Justice Breyer disagreed. First, he found
the admitting privileges requirement brought about no health benefits.
Therefore, the requirement, quote,
places a burden upon a woman's right which, given the lack of health benefit, is undue.
During oral arguments, Justice Breyer posed the question bluntly.
So what is the benefit to the woman of a procedure that is going to cure a problem of which there is not one single instance in the nation, though perhaps there is one, but not in Texas?
Study guide. Justice Ginsburg suggested that the true motive of the Texas law is to, quote, strew impediments to abortion. Is there evidence of this improper intent in the record? If not, how are courts to ascertain this intent? With respect to the second provision, Justice Breyer found that
requiring abortion facilities to meet these requirements will not provide women with better care or more frequent positive outcomes.
However,
enforcement of the surgical center requirements will place a substantial obstacle in the path of a woman seeking an abortion.
In other words, if a health law makes obtaining an abortion substantially more difficult while offering no compensating health benefits, it in fact imposes an undue burden on the right to an abortion. Study guide. Is the court's framework in Whole Woman's Health the same as that announced in Planned Parenthood versus Casey? After Whole Woman's Health, is there any meaningful difference between strict scrutiny and the undue burden standard? Justice Thomas wrote a solo dissent in which he challenged the modern court's use of tiers of scrutiny. First, he charged that the majority applied a level of scrutiny that, quote, bears little resemblance to the undue burden test the court articulated in Casey. According to Justice Thomas, Casey did not permit the court to weigh the benefits of the regulation against its cost to determine whether it was undue. Study guide. Is it really possible to determine whether a burden on the exercise of a fundamental right is undue without considering the benefits of the regulation or lack thereof? Second, Justice Thomas lamented the fact that the court has a, quote, troubling tendency to bend the rules when any effort to limit abortion or even to speak in opposition to abortion is at issue. Third, he attacked footnote 4 of Caroline Products, which, quote, created a new taxonomy of preferred rights. That approach was not limited to enumerated rights, but also included, quote, putative rights like abortion, which hardly implicate discrete and insular minorities. He continued, quote, the court has simultaneously transformed judicially created rights like the right to abortion into preferred constitutional rights, while disfavoring many of the rights actually enumerated in the Constitution. Justice Thomas concluded, quote, the court should abandon the pretense that anything other than policy preferences underlies its balancing of constitutional rights and interests in any given case.